Welcome back. Today, we will be hearing from two practicing officers of the law. Alvin Kapp, who has served in more than 7,000 cases in all areas of the law, and Maria Schneider, Assistant State Attorney for the Juvenile Division.
Our first interview will be Maria Schneider, the Assistant State Attorney in charge of the Juvenile Division.
Usually called concurrent jurisdiction, which means that the juvenile basically can be handled either in juvenile or adult court, and the prosecutor makes the decision of which court the juvenile will be handled in. So for any felony offense, if a youth is 16 or older, we decide whether they should be handled in the juvenile court or the adult court. And there is a very significant difference, because a juvenile handled in the juvenile court has outcomes, has dispositions, if they are found guilty, that are for the purpose of rehabilitating them. Whereas if they are transferred to the adult court, then the sentences are for the purpose of punishing them. So it's a really significant difference to be in the juvenile court versus the adult court. The juvenile court is all about rehabilitation. The adult court, in Florida and pretty much everywhere in the United States, adult court is about punishment, not necessarily rehabilitation. Oh, you just want me to start answering?
Just go.
Okay. All right. In Florida, juveniles are any persons who are less than 18 years of age. The minute you turn 18, you are considered to be an adult for the purposes of criminal prosecution. That's not the same in every state. Some states have the minimum age for criminal prosecution as an adult as 16. New York is one of the states. In New York City, in New York State, if you're 16 years of age or older, you're considered to be an adult for criminal prosecution. In the state of Illinois, if you have committed a felony offense and you are 17 years of age, you're considered to be an adult. So in Florida, our age is still 18. However, juveniles can be transferred to adult court under certain circumstances. If a juvenile is 16 years or older, we have a process that's okay. Although we can handle cases, of a youth of any age, typically, statistically, we know that the vast majority of offenses are considered by males between the ages of 14 and 24. Our jurisdiction ends at age 18, so the bulk of the cases that we handled involve males between the ages of 14 and 18. In terms of what type of cases, probably the most common offense is petty theft. And petty theft just means that someone has taken property that is worth less than $300 or less. And that's our most common case, although unfortunately we handle all different kinds of cases, from as simple as trespassing to as complicated as a homicide or sexual batteries. We handle just about anything. Juveniles into trouble anymore after one or two brushes with the law, and who is the child that's going to continuously get into trouble and eventually qualify as a chronic offender. So as a result of that, we try to interact in the most effective way. Most kids who get in trouble for the first time, unless it's a very serious offense, are offered the opportunity to avoid processing through the formal juvenile justice system. We have something called civil citation and diversion, and both of those are programs where an offender is offered the opportunity to voluntarily participate in rehabilitative services, and if they complete those services successfully, then the charges are dropped. So it's a really good way for kids who have gotten in trouble for the first time to avoid the stigma of having a juvenile record, which does have consequences that potentially can follow you into adulthood. And the vast majority of those kids who participate in those types of rehabilitative programs don't get into trouble again. We have great success with those. Unfortunately, then there's that small group of kids that, we try to divert them. The second, third time they get into trouble, we try to provide them with, kind of deeper end services by way of probation. And eventually we can even commitment. We can place them in residential programs. And sometimes we have success and sometimes we don't. It's really a mixed bag. But remember that usually that's a small percentage of the kids. It's a small percentage of the kids who end up in the commitment programs and being repeat offenders. Most kids really only, come in contact with the law once, maybe twice. Well, as it turns out, although juvenile records are confidential, they're not quite as confidential as most people think. They can potentially have an effect into adulthood. For instance, if people want to get into the armed services, they want to, be a member of any of the armed services. There is a pretty significant background check, security check that goes into that, and they do find out even about juvenile cases. And those can, depending on what the case is, affect someone's ability to become a member of the armed services. If someone wants to get a job in law enforcement later on in life, they want to work for any law enforcement agency, they want to work for the FBI, they want to work for the CIA. Those agencies conduct very thorough background checks, not only about any kind of serious offenses, but they'll ask kids to divulge even very minor contacts with the law. So that's a really significant potential impact. If you want to go to a really good private school, having brushes with the law in juvenile court could affect you. I'm not saying necessarily it's going to, obviously it depends on what it is. You hope that anyone who considers that kind of a background is going to use good judgment, and certainly someone who is involved in a trespass or in some kind of petty act of misconduct isn't going to be precluded from, pursuing something that they really want to in life, but it could. And since you never know what the outcome is going to be, the best advice that I can give any kid is to think very hard about what you do, because the smallest mistakes sometimes can have really significant impact. If anyone had ever been arrested, and when you're asked a question as broad as that, if you've ever been arrested, then most people would disclose if they'd been arrested as a juvenile as well. We have been able to stop that. State schools aren't asking that question anymore. State schools now, on applications for either admission or for scholarships, will only ask if someone has been prosecuted for a crime. And juveniles technically aren't prosecuted for crimes, they're prosecuted for delinquent acts. So the answer to that, with a state school, if someone has been in trouble in juvenile court, as long as their case was handled in juvenile court, would be no. But private schools can ask you anything they want. And private schools continue to ask not only about any kind of serious offenses, but they'll ask kids to divulge even very minor contacts with the law cases. And again, just because you had a juvenile case doesn't mean you're not going to get the job. It depends on what the offense was or how many times you got into trouble, but potentially, that record does follow you into adulthood. And even if you get the job, I mean, most people don't want to have to go through the embarrassment of having to discuss, something that happened when they were a kid.
And now we will hear from Alvin Kapp, a mediator, arbitrator, umpire, and special master of a wide variety in both civil litigation and alternative dispute resolution. He served as a White House intern for President John F. Kennedy while studying at George Washington University, and successfully completed the Harvard Negotiation Project. We will now hear from him about the effects of juvenile arrest on a teenager's future.
Juvenile offenses run the gamut, anything you can imagine, but I suspect that the most prevalent would be involving driving infractions, alcohol infractions, and what we would call petty crimes. The job market, the school market, is a very competitive market. And then if an employer or an admissions officer sees that there's a juvenile delinquency adjudication, the first thought that enters their mind is, why do I want the aggravation? Why do I need this person as opposed to someone who has no such record? In Florida, juvenile records are at least theoretically done away with at ages 24 to 26. The problem is that during those intervening years up to that age, that record may have been picked up by the FBI or federal authorities, other policing agencies, and as we've all come to learn, once this information exists, it's almost impossible to completely do away with. The best thing to do, I suspect, is simply to think before you act. Once the bell is rung, it can't be unrung. There are consequences. So before one drinks and drives, before one gets involved with recreational drugs of any kind, you need to think in advance about what the consequences may be and whether you're prepared to deal with them. One comes to mind where I had a 16-year-old young man was accused of vehicular homicide. Basically, he was driving drunk and struck a pedestrian. I can't tell you how many hours and how many days I spent with that young man in an orange jumpsuit being led around to jail until things could finally be resolved. Ultimately, he went to jail for 3 years. Whether or not he's ever overcome that problem, I don't know. But it affected him for his life, and it's affected his family. That's the risk that's out there.